I'd like to welcome all of you this morning to the Law Society of Upper Canada Department of Education seminar on the practice in the Provincial Court Civil Division and Small Claims Courts. This is actually the third program that's been run on these courts over the last 4 years. The first one was in the fall of 1980. The second one was in the fall of 1981. And the third is this morning. And I suppose it's apropos because the Provincial Court Civil Division itself is almost 4 years old, and considerable progress has been made since the second program in the fall of '81. And again, I'd like to welcome all of you here this morning. Just been looking around and looking at those who are in attendance to see who are the winners and who are the losers in my court. Fortunately, there aren't too many familiar people, so it's all right. I have the honor of introducing His Honor Senior Judge S.D. Turner. Judge Turner has had a very long, varied, and distinguished career, beginning with his graduation from the University of Toronto in electrical engineering, 5 years in the Air Force, graduated from Osgoode Hall in 1949, spent some time in Calgary with Imperial Oil, joined the Ministry of Consumer and Commercial Relations later in Ontario as Executive Director of the Business Practices Division. Judge Turner was appointed a judge in the Small Claims Court in February of 1976. He was appointed senior judge of this court on June the 30th, 1980, when the Provincial Court Civil Division commenced. Judge Turner, of course, some of you may know, has had a lengthy and considerable background previous to becoming a solicitor or practicing law, and that is that he has the distinguished record of playing football on 2 Grey Cup teams in Canada, one of which won and one of which lost. One team was the Argos and one was Calgary, so you know which one lost. But I'm pleased to introduce Judge Turner. I don't think, and I can say this with all sincerity, that there has not been probably one more individual member of our judiciary who's been more dedicated and hardworking in support of the growth of this court. And I'd like to introduce Judge Turner. Thank you.
Sit down and be comfortable. We'll have to get more chairs in the witness boxes, I think, too. Thank you very much, Judge Zuker, for your kind remarks. Your honors, and ladies and gentlemen, glad to have you aboard this morning. In answer to a query which may or may not be in your minds, it wasn't the Argos who lost, it was Calgary. For some time, I had maybe a distinction of being on one of the last Grey Cup winners, but everything's been changed this last fall. Now, excuse me, the Small Claims Court of Ontario has a long and honorable history. And the first such court was established in what is now in Ontario in 1792, when the first Parliament of Upper Canada passed a statute entitled An Act 'Act 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 Almost 2 centuries have passed, during which there has been a continuing effort to develop a judicial forum where a dispute involving small amounts of money could be resolved with a minimum of expense, delay, and formality, but still be handled in accordance with normal rules of law. There are 127 small claims courts in Ontario, and these courts presently handle over 75% of all civil actions that are brought before Ontario courts. It is in the small claims courts that the vast majority of citizens involved in a civil dispute first come face to face with the administration of justice, and for them, this, their first impression of justice in action in Ontario, is the one that they will carry with them throughout their lifetimes. In November '77, the jurisdiction of this court was increased from a limit of $400 to $1,000. Now, before that time, some of you may know the maximum was $200, and before that time, the maximum was $100, and even in the past, there was provision for a 6-man or person juries at one time. So things have changed a little bit. In '79, the Attorney General, the Honorable Roy McMurtry, QC, introduced a bill into the Ontario Legislature with a view toward the establishment of a provincial court civil division project within metropolitan Toronto, with having a monetary jurisdiction of up to $3,000 exclusive of interest, in place of the existing $1,000. This was the first big move, big push to move the court up the scale. Upon introducing the bill, the Attorney General stated that the goals of such a court were to provide more speedy and less expensive procedures for the resolution of disputes involving comparatively smaller amounts of money, to increase the accessibility of Ontario citizens to the courts, and to assist the County Court of the Judicial District of York in decreasing its caseload. An advisory committee was appointed by the Attorney General to draw up court rules applicable to the new court. This was a big job, and it took many months. And this 7-man committee was comprised of 3 judges, 2 senior members of the practicing law profession, a law professor, and the Deputy Attorney General of the day. The initial estimate of number of claims over 1,000, which were expected to be entered in the first year, was put at 5,000. The number was actually 12,500 for the year 1982. And these claims in the next year, for the first year was 12,500, and 82 it was 16,000, and last year about the same. And then we had, in addition, the claims under 1,000 totaled over 30,000. I mention these few statistics only to demonstrate that this court has generated all of the appearances of having been well accepted by the public and by the practicing law profession. Approximately 45% of the litigants coming before this court represent themselves. Lawyers are involved in about 18%, and the balance of representations are by articling students, law students, agents, law clerks, and with a small percentage of no-shows. The court has always had the vital enthusiasm of the Attorney General, together with the vital interest of the Chief Justice of Ontario and of other judges of significant experience, and we express our appreciation for that. And I do wish now to state our sincere appreciation of the fine efforts of all of our court and office staff. They do a very good job, an exceptional job in my view, of meeting the public and carrying out the many, many administration activities. I'm pleased to advise you that effective January 1, '83, this court became the Provincial Court Civil Division and no longer was a project court. In October '83, all 11 judges were sworn in as Provincial Court judges by the Chief Justice of Ontario. There is provision by way of regulation to extend the $3,000 jurisdiction to other areas of the province beyond metropolitan Toronto. This, of course, is a political decision, and I can't advise you at this moment of any move in that direction, but the authority is there to do it. Our present bench of permanent judges includes 8 judges in metropolitan Toronto and 3 judges outside of Metro, including a judge in Hamilton, a judge in Ottawa, and a judge in the St. Catharines area. All judges in our courts carry out their duties in keeping with the following principle as expressed in Section 57. The judge shall hear and determine in a summary way all questions of law and fact, and may make such order or judgment as appears to him just and agreeable to equity and good conscience, which shall be final and conclusive between the parties, except as herein otherwise provided. To me, the expression and the words make such order or judgment appears to him just and agreeable to equity and good conscience are simply beautiful. They give the judge a broad scope to function and fairness. We have on strength 21 deputy judges who hear claims up to $1,000 and also hear claims up to $500 in night courts. As well as sitting in metropolitan Toronto courts, the deputy judges take a high percentage of the trials in Newmarket, Sutton, and Richmond Hill small claims courts. We have a most valuable person as a trial coordinator, and more about this person a little later on. I do wish to acknowledge the work of the referees in our courts who deal with a multitude of accountings, resolution hearings on claims up to $1,000, and consolidation orders. In 1983, out of close to 900 matters referred for accounting, 40% were settled by the referees. As an overview, the court functions well. We are concerned about the large number of adjournments sought, which only add to the backlog. An adjourned case will not be heard for over 3 months. We look to the profession to reduce significantly the number of adjournments sought. This point is critical. We need cooperation and teamwork. We can all do this together. And please don't come to our court and tell me or any other judge that you're involved in some other court. That goes over like a lead balloon. Well, thank you. And now I'd like to take a moment to introduce His Honor Judge Reuben Bromstein, who will be presenting the next topic. And, Judge Bromstein was appointed to the Provincial Court Civil Division a year ago. In business for 20 years, he went back to school and obtained his BA at night and law degree at Osgoode Hall. That's quite a mouthful. Private practice was primarily related to commercial and corporate litigation, government dealings, and marketing law. Advisor to various government ministries, Judge Reuben Bromstein, was a member of Canadian Consumer Council and an independent committee for competition law revision appointed by the federal government. He was legislative counsel to some of Canada's largest business and consumer organizations, advisor to Canadian government at Vienna Diplomatic Conference on Trademarks Treaty, author of numerous articles, and has addressed business, trade, and law associations. Sounds to me as if I'm introducing a member of the Supreme Court of Canada, that we have a good bench of our own, and we're happy to have Judge Bromstein with us, and I ask him to come forward.
Thank you, Judge Turner. It's my pleasant duty to deal with the overview of the court changes, and in so doing, I'll be dealing with some of the problems that we encounter as judges or as litigants. And I guess we all have to deal with justice as and lawyers. And I guess one of the problems that we face is the uncertainties of the law. And as I was told by one lawyer who appeared before me one day, he was a little upset because he was sued by his wife for divorce on the grounds of impotency and by his secretary on a paternity charge. He was mad because he lost both cases. Well, the rules of the Provincial Court Civil Division apply in Metropolitan Toronto. The Small Claims Courts Act and rules apply to the rest of Ontario. The rules and procedures are somewhat different. Our court is unique. It's unlike any other court in the country. And the rules were created by a special committee, and they attempted to marry the rules that exist in the Supreme and County Courts with the small claims court setup. And they created a halfway house. And the rules are designed to provide, among other things, the benefits of the procedures which exist in the higher courts, which give you discovery, affidavits on production, document disclosure, and let you get to trial knowing what you're about without the costs and time incurred in the higher courts. That's what they've tried to do. Trial procedures are also summary. The changes in the rules will be applied through the rest of Ontario when the $3,000 jurisdiction appears there. Some of the changes are there now in the rest of Ontario. For example, the hearsay rule. Up until 1977, the procedures between the time of filing the claim in the defense and getting to trial were very limited. Heather, is there any glasses of water up here, please? Marvin, can I get a glass of water, please? Thank you. Thank you. Were very limited. After the defense was filed, you were on for trial fairly quickly. There was virtually no mechanism to help you find out what was going on in your case other than what was in the pleadings. In the Supreme Court and the County Court, you have an examination for discovery. During the examination for discovery, you find out more about what the other side's case is, and they find out more about what your case is. You also have affidavits on production, which gives you full disclosure of all documents. In the motions in the higher courts, you clean up your pleadings. If you've made a mistake, you can straighten that out by a motion to the court, and you don't have to wait until trial. And during that procedure, you narrow or funnel down what is going on in the case. As I said in the paper, it's like a series of food strainers. You start with a jumble of facts, which you put into the pleadings as best you can, and by the time you get to the trial, you've sifted through the material as a result of the court processes. So what you've got by the time you get to the trial is fairly clean, and you have narrowed the issues, and you know more or less what to stick to at the trial. That procedure was not available in this court before. Therefore, in order to provide the full disclosure and clearly define the issues and to help the parties know the case they have to meet and to obtain admissions, this rule committee tried to find a mechanism to give you that. And they did that in a number of ways, which I'll deal with. They've developed special rules and procedures relating to the pretrial and to the trial itself, so that higher court procedures worked to help you know where you were going. The small claims court, up until that time, didn't give you that mechanism. What we now have is an amalgam of the two, an in-between process, which helps you to get there. And the history of the court indicates that we've got to find some way of doing these things. It may interest you to know that the history of our court and the problems that the judges encounter that you face today are far less than the ones that were encountered over the years. In reviewing some of the history of the court, I came across the following in the Upper Canada Law Journal, which may interest you. The heading deals with the following: the impropriety of holding courts in taverns. And it was said, there are many and grave objections to holding a court of justice in a tavern, and the sitting should not be held in such a place if it be possible to procure another for the purpose. Well, I'm not sure how Judge Turner and the other judges would feel about that, but that's obviously something which isn't happening today. Our facilities are much better than that. But the other problems that the judges apparently encountered back in those days was the following. And this was apparently referred to by Mr. Justice Burns, who was a friend of the division court system, in one of his comments. It has also been the case that the judge has been obliged to pay out of his own pocket for fuel to warm the room, and when he has been unable to finish his cause, list before dark, to pay for candles rather than adjourn over till the next day. Well, we've come a long way from that point. And this rule committee tried to help the path be cleared. And what I'm going to try and do is overview for you what was done by the committee. The rules were enacted by regulation. They're not in the Act as such. And they include many of the sections that are in the Small Claims Court Act, but not all. And some of the modifications in the rules are very subtle, and sometimes one word can sometimes mean a different application of that rule in the Provincial Court Civil Division than in the Small Claims Court. And I suggest, when you deal with it, check the rule under our court in the Provincial Court Civil Division and check the rule in the Small Claims Court Act and see if there's any modification, and ask yourself why that modification occurred. Because every time there was a change, it was important, and the Rule Committee had a purpose in doing it. There is initially, of course, the monetary and territorial jurisdiction. $3,000 is now the limit in Toronto. You can't make a claim for over $3,000 in our court unless the amount is for interest. And the judges do not have the jurisdiction to deal with the claim over $3,000, as they don't have the jurisdiction to deal with the claim over $1,000. Unlike the county court, where if your claim exceeds the jurisdiction, there is no problem in dealing with it unless the defendant brings a motion or in some other way contests your right to deal with it. It's important, therefore, to make sure that you don't make that mistake and to catch it as soon as possible, because some of the judges are imposing cost penalties on solicitors who don't catch it in time. An unrepresented litigant, it is understood. Territorial jurisdiction is one area which has created some problems for the courts. Section 66 deals with the question of territorial jurisdiction. And that section says that the action shall be entered and tried in the division in which the cause of action arose, or in which the defendant resides or carries on business. It was thought until recently that this meant the whole cause of action. And that has created some problems, because historically there has been some confusion in the courts as to what the meaning of the cause of action is. And the history of the courts in England, where two courts went on entirely different routes as to the meaning of the cause of action, is instructive. One court held that it was the breach which was the cause of action. Another court held that it was the whole cause of action and not just the breach. Until recently, it was thought that McNeely versus Bennett, a Supreme Court case which dealt with a motion of prohibition, was the guiding case. And that seemed to say that the whole cause of action was the essential matter. In other words, every fact which you had to prove. A recent unreported decision of our court held that it was sufficient if the breach of contract took place within the jurisdiction. That case followed a British Columbia Supreme Court decision and a Privy Council decision of 1971. This case, the unreported case, was challenged in another case in which the decision is still outstanding. That decision, we understand, will probably come down as a contrary decision. If it so does, the final ruling will have to be in the hands of the divisional court. To be safe and to avoid getting into that kind of problem, it would be wiser to bring your action where the defendant resides, because it makes little sense to get into a hassle over jurisdiction for the amounts in issue. Obviously, the purpose of bringing it where the defendant where the cause of action arose in Toronto is to get the benefit of the $3,000 limit. If the jurisdiction is unchallenged in the defense, the court is deemed to have territorial jurisdiction. If it's undefended, the action will be set down for trial on the issue of territorial jurisdiction before the damages issue can be dealt with. There is an affidavit provided in the material which you can use, which may help you to avoid an attendance at trial. Query: whether the court can hear a motion to strike territorial jurisdiction before it is set down for trial on the issue of jurisdiction. There will be a decision issued soon on that because that matter was raised in our court. Your pleadings should be concise and in non-technical language. We have provided some precedents at the back of the book. If you look at them, you'll see that we've tried to find some which are as simple as possible. You don't need to use the technical language that you tend to use in the Supreme and County Courts. That is because unrepresented litigants provide fairly simple claims or defenses, and the solicitors and other people who act for the litigants should be able to do the same thing. You don't need to use the phrases such as the plaintiff pleads and relies, or it is alleged that. The simple pleading on page 17 of the material is one that might be useful. Mr. Smith bought a car on January the 7th, 1983 for $1,500. The contract is attached. He paid me $500 and still owes me $1,000, which he refuses to pay. I claim $1,000 together with prejudgment interest and costs. If the contract, which is attached, doesn't state where it was made and where the payments were to be made and other important facts, then you should say so. That's about all that you need. But make sure the important facts are there. Why? Because if the claim is going to go uncontested and, for example, comes up for a damages hearing, if the key facts are there in the claim, they are taken as accepted and proved. If they're not there, you're going to have to bring witnesses to prove them or to provide affidavit evidence. And you may save yourself some time if the claim provides the relevant information. The defense should also be as short as possible, and it can also contain the counterclaim. You can bring in a third party, and please remember that a third party claim does not have as its test the tests that are in the Supreme Court under the rules of practice. It's very simple. If the claim arises out of the same transaction or occurrence relied on by the plaintiff, or arises out of the claim made by the plaintiff, you've got a third-party claim, so bring it. There's no specific provision for fourth-party claims and subsequent claims, but as a matter of practice, they're accepted. Service is done by the bailiff of the court. There's one slight error or poorly worded phrase on page 19 where it says there's no extra charge for this service. It should really say that bailiff's fees for service are paid at the time of issuing the claim. A solicitor, under the new rules, can serve the claim directly. If there's any problems with service, there's no need to necessarily attend on a motion. An affidavit supplied to the court in relation to substitutional service is sufficient. The clerk will automatically sign judgment if no defense is filed, if the claim is for a liquidated amount. That's why I suggested you provide sufficient particulars to show the basis of the claim. Affidavit evidence may avoid the attendance of witnesses. In the back of the book, under the precedents, you will find some affidavits which are fairly good examples of what you can use when you attend to deal with damages and which would avoid the attendance of witnesses. You can save a lot of trouble that way and a lot of time. A default judgment may be set aside on motion. When you do that, it would be helpful if you supplied the defense at the same time. That'll save you coming back another day to file it, and it'll help the court to determine if you have a legitimate defense. One of the rules that has not been used as much as it might otherwise is the option for the defendant to admit liability for all or part of the claim and ask the court to impose terms of payment. The short-form financial statement is added to the defense and the referee arranges for a hearing. And the court will order the terms of payment that can be made based on ability to pay. The order will usually provide that the judgment can be signed by the clerk for any unpaid balance if there's default in payment, simply by the plaintiff providing an affidavit setting out the default and the balance to the clerk. Discovery is only available by judge's order in cases over $1,000. We find the discovery is rarely necessary because of the special pretrial procedures which have been developed in the court. The pretrial procedure is followed where the claim exceeds $1,000 because all of the claims and defenses are provided to judges of the court who review them after the defense is filed. And we go through them and we try to separate them into three piles. A pile which deals with those which should be sent to pretrial, ones which would be sent to the trial directly, and ones which would be sent to the referee for an accounting hearing. Or even occasionally where it's a mixture of accounting and the referees might be able to in some way help to settle it because they're very good at that. A pretrial judge usually has three main objectives when he gets the material. He tries initially, when the parties appear, to deal with any pretrial interlocutory matters such as cleaning up the pleadings, making sure that all the proper parties are added or properly named, ordering particulars without the requirements of a formal motion. So when you come to the pretrial, it would be helpful if you knew what the problems were that you were concerned about, that you wanted to clean up, so that you could tell that to the court, and the court would then be able to make those changes without wasting time at a special motion or at the trial. But the pretrial also acts as a mechanism for disclosure, and you would then be asked to exchange all documents and to tell each other all the facts that you might be relying on at trial. It's essentially the same mechanism in shortened form as exists in the discovery procedure in the higher courts or by the affidavits on production used in the higher courts. The trial judge will then prepare a summary for the judge hearing the case. The pretrial judge. The pretrial judge will not, without the consent of the parties, be able to sit on the trial itself. That is because he then tries to find some way of settling the matter between the parties and giving a sort of quick judgment of what he or she thinks will happen. Not always, but quite often. And it'll give you a feeling about what's going to happen to your case that you can take back to your clients. This often results in settlements. That is one of the key purposes of the pretrial, as it is one of the key purposes of many of the rules that are set down in our court procedures. Settlement. we try very hard to get people to settle because it saves time, it saves money, it saves aggravation. Payment into court is one mechanism for settlement. I've mentioned about the case which you should be concerned about in relation to payment into court on page 23. Because it was held in one case where the payment into court was made in full satisfaction in relation to a motor vehicle property damage claim to be a full release of the personal injury claim. There was a slight difference in the wording in the Small Claims Court Act, if memory serves me correctly, and the one in the Provincial Court Civil Division rules, which may mitigate the effects of that case. But I think you should be aware of it. And I've posed a question on page 23, which might be a possible answer to the problem that occurred in that case. The other mechanism that we have that we feel is quite useful, and of course we would like the input of the bar and other people, is Rule 44, which I like to call the Colt 44 solution. It's like a shotgun shareholders agreement, which essentially puts each side to the test of a settlement. It works as follows. You make a written offer of settlement to the other side, which is not shown to the judge until the end of the case. At the end of the case, when judgment is given, the judge sees the settlement offer, and he sees whether it's better or worse than the amount. If the plaintiff, for example, decides to accept an amount in the settlement offer of, let's say, $1,500, and his judgment is for more than the $1,500, he will be entitled for the judge to consider giving double costs if the settlement offer isn't accepted. And because solicitor's fees can be $300 and pleadings can be $30, and you might add up to $400, double costs can work out to $800. If the defendant makes an offer, for argument's sake, of $1,500 and it isn't accepted, and the plaintiff gets judgment, but not for $1,500 and gets less, let's say $1,499.99 or $2, the defendant will get costs and the plaintiff will not get his costs even though he won. There is one slight gap in the rules relating to that, and that is why the defendant doesn't get double costs. But that's a matter which we may deal with in the new rules if there's any way to deal with that. I've also posed a question on page 24. If the settlement offer doesn't specify a payment date and the payment isn't made, can the plaintiff claim interest from the date of the acceptance of the offer until payment? I would think that you can get the interest, but I'll leave that to you. Motions will be dealt with later. Adjournments. The problem of adjournments is tricky because if we try to develop the procedures in the higher courts of using a lot of assignment courts and advanced trial lists, you're going to be forcing people to come to court for another day, either the solicitor or the litigant. And that isn't necessarily the best thing to do in a court of summary jurisdiction, which tries to save people time and money. The problem of adjournments, of course, arises because we don't have those procedures and because you're faced with a trial date without much opportunity to prepare for it or to get your witnesses in and have everything ready. So we're trying to work out ways of dealing with it, particularly if you, for example, give us sufficient warning for the adjournment. Then there's very little doubt that you'll get it, regardless of what the problems are. If you don't give warnings, then we've got problems. As Judge Turner mentioned, trial procedures are also summary and simplified because we try to deal with them on the basis of equity and good conscience. That gives us, we believe, considerable discretion on procedural matters, so that unless a case or statute specifically binds us, we think that we have the jurisdiction to use our understanding of equity and good conscience to come down with a fair decision. Most cases are dealt with fairly expeditiously and don't take that long. Cases are, however, becoming longer, and we are getting cases where people tend to become more particular about how we deal with them, and that is presumably because of the increased monetary jurisdiction of the court. That's understandable, and we're going to have to live with that. Everybody wants us to be fair and to make sure that justice has triumphed. And I guess you're all familiar with the lawyer who on holidays received a cable about the fact that justice has triumphed, and he immediately wired back appeal at once. Hearsay evidence at trial. We can accept hearsay evidence at trial. The purpose of that rule is to try and shorten times at trial. You take risks when you permit a trial judge to hear hearsay evidence. There's a reason for the hearsay rules. We try to use our common sense when we use the hearsay rule and decide whether we wish to believe people or not. It's a trade-off, as is every other procedure that we've developed, between expediency and justice. We try to make sure that we're not avoiding dispensing justice while trying to save time. It saves witnesses being called in many cases. But if a witness is crucial to your case, for example, in a motor vehicle trial, an independent witness would be that kind of situation, we suggest that you make sure that that independent witness is here and that you not take the chance on hearsay evidence. You should use written statements and documents at trial much more than people do. The rules permit you to serve written statements and documents on the other side at least 20 days before trial. And that evidence is admissible unless the judge orders otherwise, or the other side, on at least 10 days' notice before the trial, demands that the person be produced. And I've set out on page 28 where you can use those kinds of procedures. On relatively minor matters, for example, you may find that quantum may be agreed on if you provide the documentary evidence while disputing liability, or vice versa. Signed written statements of witnesses, including expert reports, can be used in that way. It saves you bringing the witness or the expert to trial. And many people simply don't use that when they could have, to save themselves time and trouble. And I would urge you to consider using that rule more often. We obviously encourage last-minute settlements. Unrepresented litigants create problems for the judge if one side is represented. And there are minutes of settlement in the precedents supplied, which we would suggest that you use, which avoids the judge being faced with the counsel on one side saying he's consented to judgment. We'd suggest that the minutes of settlement not provide a consent to judgment, but only a consent to judgment in the event that the amount isn't paid within a specified period of time. Counsel fee is increased under the rules. We suggest that the mechanism in our rules helps save time and costs. It may not be the best mechanism. There may be better ones that we could develop. We think that the rules have helped you serve your client better for less cost. They have helped you, but we believe, to decide which person provides the best function. Lawyer, clerk, secretary, litigant themselves, and someone else will deal with some of the things that other people can do during the program. The rules are a halfway house, and we think that they can do some of the job. We'll be revising the rules when the new Courts of Justice Act comes in to try and cover the problems that were not covered and hopefully deal with them in some equitable manner. There's a trade-off between the conflicting objectives of the court and quick rules. Obviously, quick rules don't provide always the most effective justice. We try to find the best trade-off in the rules and in the way we deal with them in the court. You can help us as the rules are discussed in the next year or so by telling us what you think are the problems that we have not dealt with satisfactorily, or that we as judges are not dispensing properly. You can help us make sure that the rules, when they come down, are a little better. We need your help, because sitting up there deciding cases isn't always the best method of deciding where we go wrong, because we know we make mistakes. We do our best, but we know that we make some. You'll have to help us avoid those and minimize the number that we do. We think that the resulting savings in time and money that the rules have created, and that the mechanisms in our court help ensure are worthwhile. You can help us make sure that continues. I'd like to close with a story that John Diefenbaker used to tell about judges, so that you'll understand that we don't always think we know everything. It was a hard-drinking prairie judge was found by a young lawyer sitting aboard a horse but facing astern. When the lawyer brought this to the attention of the judge, he was told never to offer a judge advice unless asked. And then the judge added, and besides, how do you know which way I'm going? Thank you. I'd like now to introduce, it's my honor to introduce His Honor Judge Zuker. Judge Zuker was appointed to this court in 1978. Since that time, he has been involved in several local, provincial, and national seminars on the small claims court. He has worked extremely hard in the areas of the rules and in every possible area which would help the development of this court. He has written many articles and related publications on this court and has extensively lectured in this area. He was a member of the Provincial Court Civil Division Advisory Committee, which drafted the rules which we're discussing. So a lot of those things that you like are partly his responsibility. The ones that you don't like, you can hit him with. He's also co-chairman of the Law Day Ontario, which will be held on April the 17th, 1984. He feels passionately about bringing law to the people, and he does, we think, a good job. Judge Zuker.
Thank you very much, Judge Bronstein. I'm going to introduce several panelists who will come up and give you talks on various subjects. Before I do so, however, all of you have this form that's attached to the additional materials I think that you were given this morning. And I would ask you to fill them out. There are two panels. One panel which will be beginning momentarily, and another panel after the coffee break. But if you have specific questions of this panel that's coming up now, please write down your question and who the question is addressed to. Of course, you don't have to sign your name if you don't want to. I would only ask that you confine your questions to the area of law. I was going to introduce Judge Turner first, and he's just stepped out, so I think I'll move on to Mr. Soderberg. Rick Soderberg, some of you may have met him personally if you've ever been to the Etobicoke Small Claims Court, if you've ever filed a complaint, not filed a complaint, but filed a claim. I suppose if you had a complaint, oh, here's Judge Turner. Perhaps we'll get him then to come up, and I'll save Mr. Soderberg for next. I'll introduce Judge Turner, who I've introduced earlier, to deal with the general outline of non-represented clients and other related matters concerning this panel.
Thank you. The beautiful big binder that you have was contributed to by all the persons named and put together so well by the Law Society team, for which we say thank you sincerely. It contains 11 pages of scholarly dissertation on the problems encountered by the unrepresented litigant. I strongly recommend you read those pages at your leisure. For now, I have just a few minutes to comment on this interesting topic and others. Through the eyes of the litigant, these thoughts may well pass through the litigant's mind. So you have been sued by someone, or you have feeling that you would like to sue somebody, and you've been served with a copy of a claim if you're a defendant or you have arranged for service of a copy of your claim. What am I going to do? How do I go about it? Oh my goodness, or some stronger expression. Where can I get some help? I've never been in court before and haven't the foggiest idea of how to go about it. What is the tough old judge going to think about me and my presentation? Well, first of all, cool it. Sit down quietly and think about your situation. It is really a matter of common sense. You can represent yourself in court, and the court costs are relatively modest. If you're the plaintiff, sit down and write out the basic issues upon which you base your claim. You do not need to go into detail at this stage. Leave that for the trial, when you can fill in the details when you are telling your story in the witness box. If you are the defendant, consider the issues put forth by the plaintiff in the claim and write out the basic issues on which you base your defense. Again, you can fill in the details at the trial. Using the court forms which are available, each party must fill in the claim or the defense and file with the court. You will find the court staff extremely cooperative. They are able to assist you with procedure, but don't expect the court staff to come up with legal advice for you. They're not in that game. At the trial, keep calm. Tell your story in a straightforward manner. Know your facts well. Do not repeat yourself. Remember, there is a judge listening to every word that's said. Do not become emotional. Give your answers to questions in a concise manner and then be quiet while you wait for the next question. Do not argue with your opponent, and above all, do not argue with the judge. Bring with you any witnesses who can be helpful to your position. I suggest you consider using the subpoena approach, whether it's a friend or not. Good photographs are useful. A sketch of the relevant scene can be very helpful. For example, in a motor vehicle accident. All in all, you should find the exposure one that you'll never forget. Well, just in sounds like motherhood, I suppose, but that was my effort to try to talk to the unrepresented litigant. But I do suggest you read that dissertation I referred to. Miss Carmen Carnavale was appointed as trial coordinator in November 1982, primarily to direct the scheduling of actions to be set down for trials and pretrials in the Provincial Court Civil Division in Metropolitan Toronto. Her role is to ensure optimum benefit of judicial time and the maximum utilization of courtroom facilities. During the past year, Carmen has implemented and is presently maintaining a pretrial system for all 4 metro courts. That's Etobicoke, North York, Scarborough, and College Park. Notices of pretrial are mailed to the litigants at least 21 days prior to the pretrial date, thereby allowing parties some flexibility in the event that an adjournment is required. Settlement of pretrials should be reported to the trial coordinator as soon as counsel is aware of any settlement. This is so that another action may be slotted in its place. If a case is ordered to pretrial, the pretrial will most likely be heard within a 2-month period. In the year 1983, 1,871 cases were ordered to go to pretrial. About 20% have settled at the pretrial. While it's said that they haven't any statistics to tell you what has happened to cases after pretrial and before trial, the reason being that this takes physical time for somebody to assess all the files, and everybody's been rather busy, and we haven't had a person we could set free to go through the multitude of files. But we do have a sample for you And out of a sample taking of 140 cases that went to pretrial, 18% settled at pretrial. 48% settled after pretrial but before the trial. So the total settlement figure amounts to 65.6%. It's frankly a lot better than I had thought it was. And then the remaining 34.3% went to trial. So that's a sample for you of what's happened, but only with respect to 140 cases. Picked at random, I might add, not selected. During the past year, Carnivale has been responsible for the scheduling of trials for actions over 1,000 for the College Park Court only. She has modified the previous system slightly in that rather than sending out trial notices immediately, that is after the defense is filed, she carries a backlog of cases in order that defenses in the order that defenses are filed. This ensures that the oldest case gets the earliest possible trial date. Trial notices are mailed up to 2 months in advance of a court date. That's why I said earlier, don't come to court and say you're busy in some other court after having all this notice, because you will not receive a very pleasant reception. Adjournments may only be granted 14 days prior to trial date, and only if the adjournment is on consent of the parties concerned. Settlements should always be reported by telephone initially to the trial coordinator, immediately, so that another case can be slotted in to take its place. For January the 30th, 1984, Ms. Carnivale organized our very first assignment court involving cases that have been pre-tried and where the estimate of the trial time, the length of the trial, was 1 day or longer, if you can believe it. Here we are, a court of summary jurisdiction, and we're facing cases estimated at 1 to 2 days. In 1883, at College Park alone, there were 2,569 cases ordered to go to trial. 1,498 of those cases were screened by a judge and were ordered straight to trial. 706 cases were ordered to trial after a pretrial had been held, and 365 cases were adjourned to a date to be fixed by the trial coordinator. If these 365 cases had been dealt with by the trial coordinator prior to the court date, 365 cases could have been slotted to replace them, thereby decreasing our current backlog of 511 to 146. Again, the trial coordinator stresses the job of the trial coordinator cannot succeed without the full cooperation of the bar in reporting settlements and in dealing with adjournments at least 14 days prior to court date. Thirdly, I've been asked to say a few words about the duties of the bailiff, and this is all set forth for you on pages 41, 42, and 43, so my remarks will be very brief. The duties of the bailiff are to promptly serve all documents delivered to him by the clerk and to enforce all warrants and executions. The bailiff should be prepared to answer any questions of a procedural nature and explain the processes involved. And thereafter set out the different types of services: service of a claim on an individual, service of a claim on a corporation, summons to witness. Summons to witness should be issued at least 14 days before the trial date and should give the full name and address of an individual to be served. judgment summons and show cause summons, warrants, execution of goods. The bailiff will attend at the address shown on the execution and endeavor to satisfy the judgment at the earliest possible opportunity. If he is unable to make satisfactory arrangements and must proceed by way of seizure, the methods are set forth which he must comply with. So thank you, Mr. Chairman. I think that takes care of my allotted time.
Thank you, Judge Zuker. The next panelist that I'd like to introduce is, as I mentioned earlier, Rick Soderberg, who is the clerk of the Small Claims Court, Provincial Court Civil Division in Etobicoke at 2265 Keele Street. Rick has had a long career with the Ministry of the Attorney General, commencing in 1960. Initially, he began as a deputy clerk in Richmond Hill. He became the clerk in 1970 in Richmond Hill. And in 1977, he became the clerk of the 12th Small Claims Court in North York. It is perhaps because of his lengthy career in moving from Richmond Hill to North York that he decided to leave the ministry, and he joined Newsom and Gilbert. His career at Newsom and Gilbert was somewhat less lengthy than his career in the ministry, and he decided, after selling forms at Newsom and Gilbert, that he would give some forms out in our court and rejoined the Ministry of the Attorney General in 1978 and became clerk of the 8th Small Claims Court in Etobicoke, which was amalgamated in 1980 with the 11th Small Claims Court in Mimico. So I have the pleasure of introducing one of our 4 Metro Court clerks, Rick Soderberg, who will speak to you for a few minutes.